Well, hello, everybody. It's always a pleasure to be back among the family lawyers. You're all such lovely people, yeah. But it's a particular honour to be here to celebrate the life of a remarkable woman who devoted herself to helping other people with their problems, specifically, of course, women and children, who are still noticeably disadvantaged even in today's justice system. Katherine had a very strong sense of social justice. Now, I remember meeting her when I was a trustee of the Nuffield Foundation, and she was a member of the committee which dispensed the Elizabeth Nuffield Education Fund. Now, this was a fund which awarded comparatively small sums of money to make it possible for women to pursue the sort of education which would enable them to earn their own living. And most of the applicants were single parents from minority groups. Now, Katherine confessed to me that she was a bit concerned that she was doing a sort of Lady Bountiful act. So you can just imagine it. She was doing good, but she was worried about doing good because it might make her look too posh. So, there we go. But we both knew that it was doing a great deal of good, and mainly for women with children. Women's rights and children's rights are intimately bound up with one another, which is why I chose to talk about children's rights in honour of Katherine. Now, the idea of children's rights goes back a long way, at least as far as Eglantine Jebb, one of the remarkable Jebb sisters, and it was she who founded the Save the Children Fund, and she drafted the first Declaration of the Rights of the Child in 1923. It was a simple and direct document. 1. The child must be given the means for its normal development, both materially and spiritually. 2. The child that is hungry must be fed. The child that is sick must be nursed. The child that is backward must be helped. The delinquent child must be reclaimed. And the orphan and the waif must be sheltered and succoured. 3. The child must be the first to receive relief in times of stress. 4. The child must be put in a position to earn a livelihood and must be protected against every form of exploitation. 5. The child must be brought up in the consciousness that its talents must be devoted to the service of its fellow men. Well, what is there to quarrel in that? Apart, I think, perhaps from item 5, because that's a value judgment about a good life, isn't it? Which those who believe that life should also be about the pursuit of pleasure and profit might disagree. And of course, we now all ought to bridle at calling a child it. Do you know people still do that? We have to fight against it all the time. But the rest of that is surely what we owe to every child. The following year, her declaration was adopted by the League of Nations as the Geneva Declaration on the Rights of the Child. And the UN Convention on the Rights of the Child of 1989 simply spells out those rights in a great deal more detail and extends most of the rights granted to all people in later human rights instruments to children as well as adults. And it doesn't refer to the child as it. But do children really have rights? Rights which other people are bound to respect, whether or not they think they're in the child's best interests? Or do they only have interests, the right to have other people do what those people or the authorities think best for the child? The Universal Declaration of Human Rights of 1948 boldly declares that all human beings are born free and equal in dignity and rights. But it then goes on to say that, quote, they are endowed with reason and conscience and should act towards one another in a spirit of brotherhood. Well, now, of course, they'd say sisterhood too, wouldn't they? But in other words, the foundation for human rights is the universal human capacity to reason and make moral judgments. But babies and young children can't do this yet. So philosophers and academic lawyers have argued for ages about whether children really can have rights. Mainly because they don't agree about whether people who have limited capacity to make choices can be said to have rights at all. Although they would agree that the children have a right to grow up, but that's it. Well, the Convention on the Rights of the Child of 1989 showed how far the world had moved on since the Universal Declaration. It established the principle that children were rights holders from the moment they were born. They were not just becoming human beings, they already were human beings. And the best illustration of this is in Article 7. The child shall be registered immediately after birth and shall have the right from birth to a name, the right to acquire a nationality, and, as far as possible, the right to be cared for by his or her parents. And this is reinforced by Article 8, which requires that states parties undertake to respect the right of the child to preserve his or her identity, including nationality, name, and family relationships as recognised by law without unlawful interference. End of quotation. So this recognises the child as a person from day one. And the child also has the right to a name, to a signifier of his or her unique identity. I well remember, soon after my daughter was born, taking her to the doctor, who asked whether we wanted her included amongst his patients. And this was the first time that it occurred to me that she was a real person, separate from me. Very important lesson. Now, it's worth remembering how important the right to an identity is, the right to be recognised and counted as a human being. It's the necessary foundation of all the other rights. We tend to take it for granted in this country, where we think that birth registration has been efficient and more or less comprehensive since at least 1836. But there are millions of children elsewhere in the world whose existence is not officially recognised and counted, and who may be denied their basic status as human beings as a result. So that's number one. The UN Convention contains several different kinds of rights, with reciprocal duties placed upon parents and the state. And the United Kingdom has a decidedly mixed record in implementing those rights. And this is, of course, because the Convention is only binding in international law. And I'll come back to that in a moment. This doesn't mean that it can always be ignored, even in England. The most often cited state duty is in Article 3.1. In all actions concerning children, whether undertaken by public or private social welfare institutions, courts of law, administrative authorities, or legislative bodies, the best interests of the child shall be a primary consideration. And the Supreme Court of the United Kingdom had to decide what this meant and how it applied in the law of the United Kingdom in a case called ZH Tanzania against the Secretary of State for the Home Department. And this was about two children who'd been born and lived all their lives in England, where they were well established in their schools and local community. They were British citizens because their father was a British citizen, but their mother was not, and she had an appalling immigration history. She'd overstayed her leave to be here by many years. She'd made 2 unsuccessful applications for asylum under false names, and she'd been refused the benefit of an amnesty because of her bad behaviour. The children, of course, had been conceived when both their parents knew that their mother had no right to be here. So the government planned to deport her back to her own country. And this meant that the children would have to go too, because there was no one else to look after them. Their father was an HIV-positive alcoholic. So the children would be uprooted from their home, their school, their friends, and all the benefits of living in the UK and of UK citizenship. They'd have to go to a country which they didn't know, where they were not citizens and therefore not entitled to live, and where their futures would be most uncertain. Now, as you all know, Article 8 of the European Convention on Human Rights says that everyone, children included, has the right to respect for their private and family lives. And the government mustn't interfere with this right, except for one of a defined list of worthy aims, and the interference must be a proportionate way of achieving that aim. So the Supreme Court held, and indeed by the time the case got to us, the government conceded that to deport their mother would be a disproportionate interference with the children's right to respect for their private and family lives. The European Court of Human Rights in Strasbourg would expect us to interpret and apply Article 8 consistently with our other obligations in international law, including Article 3 of the Convention on the Rights of the Child, saying that the best interests of the child must be a primary consideration. This doesn't mean that the best interests must always prevail. They might be outweighed by other factors, but these children were not to be blamed for the bad behaviour of their parents. So in reality, their best interests had to come first in this particular case. Now, the same principle has been held to apply in other cases involving governmental interference in private and family life, although with very limited success. There was a case called HH, where several extradition cases were brought together, and it did result in one mother not being extradited to Poland. And there was a case called Collins, the Secretary of State for Communities and Local Government, which is a planning case about a gypsy encampment, where, it was held that the best interests of the children involved should be a priority, but the result was unchanged. And of course, we all know how controversial this can be if applied in the immigration context. And one gathers that the government, even as we speak, is having another look at it all. However, I think that was some progress. But Article 3 does illustrate one of the dilemmas around children's rights. For adults, as I've said, to have a right is to have a choice. You can choose how to exercise it, whether or not to enforce it. But to do that, you have to have the mental capacity to make a choice. Older children may have that capacity, but younger children don't. So choices have to be made for them. And the Convention places the primary responsibility for making those choices upon the child's parents. Article 7 says that the child has, as far as possible, the right to know and be cared for by his or her parents. And there are other articles to the same sort of effect. But what if a child does have the capacity to choose and chooses to do something which is not in his or her best interests or the parents don't like? Actually, that happens all the time, doesn't it? Well, a striking example of the difference between children's rights and children's best interests is medical treatment. We allow children to say yes to medical treatment, but we are unsure about allowing them to say no. As you know, the Family Law Act 1969 says that the consent of a 16 or 17-year-old to any surgical, medical or dental treatment shall be as effective as if he or she were 18. And if he or she has given an effective consent, it's not necessary to obtain the consent of his or her parent or guardian. And we also have the decision of the House of Lords in the well-known case of Gillick and West Norfolk and Wisbech Area Health Authority, where the House of Lords held that a child under 16 could give a valid consent to contraceptive advice and treatment, provided that she had the competence to make the decision. And Lord Scarman said this: as a matter of law, the parental right to determine whether or not their minor child below the age of 16 will have medical treatment terminates if and when the child achieves a sufficient understanding and intelligence to enable him or her to understand fully what is proposed. So competent younger children can consent to medical treatment whatever their parents want. But did Lord Scarman really mean whether or not? In other words, that a competent child can refuse as well as consent to medical treatment? I think the logic of what he was saying is clearly to the effect that parents lose their right to decide on medical treatment one way or another once the child gains it. But there were cases decided in the 1990s when the Court of Appeal allowed doctors to treat children against their will. In one case, the court authorised the compulsory use of antipsychotic drugs to treat a 15-year-old suffering from increasingly paranoid and disturbed behaviour. In another, it authorised the compulsory treatment of a 16-year-old in a dangerously anorexic state. And in a later case, the court authorised a local authority forcibly to remove a disturbed 15-year-old from home to a specialised psychiatric unit for assessment and treatment, despite having held that she was Gillick competent. But these were cases where the court overrode the child's objections. And it's one thing for a court to do this. One hopes, after a fair trial, in which the evidence and the arguments for and against the treatment are examined and a reasoned decision made. It would always be that way, would it not, Sir Andrew? Yes. It's one thing for a court to be able to do this. It's quite another thing for parents to have the power to force their wishes on a child who objects to their decision. Although it wasn't necessary for the decision in the Court of Appeal cases I have mentioned, the Master of the Rolls said then, this is in the 1990s, that anyone with parental responsibility for a child, which would of course include a local children's services authority if the child was subject to a care order, could authorise doctors to carry out much needed treatment despite the patient's own clear opposition. This does look inconsistent with the Gillett principle as stated by Lord Scarman, with the whole idea that children have the right to choose and with the need for protection against unjustified interference with their rights. But of course, if the child were not Gillett competent, the parents would still have the right to decide. So that's one illustration. An even more striking illustration of the dangers of an approach which would allow parents to override the rights of a child is deprivation of liberty. Article 5 of the European Convention on Human Rights says that everyone has the right to liberty and security of person. No one shall be deprived of his liberty, save in the following cases and in accordance with a procedure prescribed by law. It then sets out a list of reasons, which include the detention of a minor by lawful order for the purpose of educational supervision, and the lawful detention of persons of unsound mind. But everyone detained is entitled to have the lawfulness of his detention decided speedily by a court which can order his release if the detention is not lawful. So the court decisions mentioned earlier, allowing children to be detained in psychiatric hospitals for treatment, were probably not in breach of Article 5. But can parents also deprive children of their liberty? Well, obviously they do it all the time, don't they? Young children do sometimes have to be deprived of their liberty, not allowed to run across the street or go out alone at night, for example. So in Cheshire West, the Supreme Court held that restrictions only become a deprivation of liberty for the purpose of Article 5 if they are more severe than is normal for a child of that age. Mind you, parents do seem to me to be more restrictive of their children's liberty these days than they were when I was growing up. So it may be harder to tell what is normal. Parents don't seem to allow their children, especially their girls, to go out alone at night at all. Well, or to go out and on their own on the streets using public transport. They seem to be driven from place to place. So there's a lot more restriction going on. But there we go. Now, in Birmingham City Council against D, a teenager with multiple mental health problems was placed by a local authority in a residential home where the restrictions on his movements deprived him of his liberty. That was common ground. When he reached 16, the local authority asked the courts whether the placement was lawful, arguing that it didn't need the authority of a court because his parents had consented to it and the child lacked the mental capacity to decide for himself. The Supreme Court held that parents could not authorise the deprivation of liberty of a 16 or 17-year-old. A court had to decide whether it was lawful in his best interests. But there is a case, currently going through the courts, about whether a local authority with parental responsibility can authorise a 14-year-old child who is not Gillett competent to be deprived of his liberty without going to court, a case called Reed J. The High Court judge held that they could, the logic being that if parents and others with parental responsibility can consent to the medical treatment of a child who is not Gillett competent, why can they not consent to depriving him of his liberty? The Court of Appeal has allowed the appeal and has announced that it's allowed the appeal, but I can't tell you why, because they haven't yet given judgment. But I think I can guess. Now, Article 37 of the UN Convention does say something very similar to Article 5 on the question of deprivation of liberty, including the right to access to legal assistance and to challenge the legality of the deprivation before a court or other impartial authority. But the Convention does not spell out the child's right to self-determination, only his or her right to be consulted. Article 12.1, for example, requires states parties to assure to the child who is capable of forming his or her own views, well, I think my 5-week-old baby was capable of forming her own views. When I visited her in the special baby care unit at Stepping Hill Hospital in Stockport, which I did every day while she was kept there, the nurse said one day, "Your daughter, Mrs. Hoggart, has a mind of her own." Well, she's 53 now, and she definitely does. Yeah. So there we are. That's allowing them to have their say, in particular. And the right to be heard is, of course, a great advance on the duty to be seen and not heard, as my father used to tell his children, but it was only a joke. But it's emphatically not the same as a right to decide. And the UN Committee on the Rights of the Child, in General Comment number 12, explains that it is a way of securing that decisions are made in the best interests of the child. So it's clear that the duty in Article 3 to make the best interests of the child a primary consideration can override the duty to consider and respect the child's views. The emphasis is on protection. And there are lots of articles in the Convention which deal with the protection of the child from all sorts of harm. There's a raft of articles about various kinds of harm. I won't list them, but there are many, many there. And of course, the UK does have mechanisms for protecting children from harm, although there is always room for improvement, especially as new sources of harm emerge from smartphones and the internet and the like. But I'm grateful to Sir Andrew for reminding us that even sources of harm which we recognised several decades ago may not be being adequately recognised to this day. We must continue in our vigilance. And the most recent observations on the UK from the UN Committee on the Rights of the Child, for example, expressed concern about, quote, the high prevalence of domestic abuse, sexual exploitation, gender-based violence and other forms of violence against children. And the UK is regularly criticised by the committee for its failure to outlaw all forms of corporal punishment. As in England, it is still a defence to a charge of assaulting a child that a parent has only been inflicting reasonable chastisement. And although this doesn't allow the parent to do actual bodily harm to the child, it can easily be misunderstood. Although I do find it hard to believe that the father of Sarah Sharif, who was tortured and murdered by her father, stepmother and uncle, really thought that what he was doing was reasonable chastisement. So we've got the protective rights, we've got the welfare duty, and we've got, however, another raft of articles which gives children the same civil rights as other people. The right to freedom of expression, the right to freedom of thought, conscience and religion, the right to freedom of association and of peaceful assembly, and the right not to be subject to arbitrary or unlawful interference with his privacy, family, home or correspondence. All of these have their equivalent in the European Convention. All can be limited or restricted for certain reasons, just as they can for adults. But Article 14 of the UN Convention also recognises the right of parents to guide their children in the exercise of the right of freedom of thought, but, quote, in a manner consistent with the evolving capacities of the child. One of several examples of recognising that children develop and their rights should develop with them. But how seriously do we take these rights? Let's take two examples which feature in a wonderful book called Rewriting Children's Rights Judgments. In AAA, against Associated Newspapers, this was about a series of articles appearing in the Daily Mail alleging that Boris Johnson had fathered a child after a brief liaison with the mother. And a photograph of the little girl in her pushchair was published a few times to illustrate how much she looked like him. Basically the hair. Her name was published in every article, and she was awarded damages for the publication of her photograph, but not for the publication of, which then stopped, but not for the publication of her name, which didn't. The court held that her reasonable expectation of privacy was weakened by the fact that her mother had talked to the media about her paternity, so the press could go on publishing her name. Neither the trial judge nor the Court of Appeal discussed how the child's right to privacy could be reduced by her mother's actions. So that's one example. And then there's a case called Castle against the Commissioner of Police for the Metropolis. And that was about 3 teenagers who took a peaceful part in a large demonstration against university tuition fees. When it seemed that the demonstration was getting out of hand, the police decided to kettle several thousand demonstrators, including these 3, in Whitehall for several hours. It was freezing. There were no adequate toilet facilities and no food or water. They weren't allowed to leave. The High Court held that the police did have a duty to have regard to the need to safeguard and promote the welfare of the children when policing the protest, but that it had not been breached, which is surprising in itself. And a children's rights analysis might have added a few more factors. It would have taken into account their need to develop their personalities and experiences through safely engaging in peaceful political activities. They shouldn't be deterred from doing so in future, as these children had been. And the police should have foreseen that large numbers of children were likely to be at the protest and made specific plans to safeguard their welfare, which they hadn't. So there we are with children's rights of assembly, freedom of thought and speech and the like. The UN Convention also contains a raft of articles aimed at securing benefits and appropriate services for children, such as the right of the child to the enjoyment of the highest attainable standard of health and to facilities for the treatment of illness and rehabilitation of health, the right to benefit from social security, the right to a standard of living adequate for the child's physical, mental, spiritual, moral and social development, and the duty of the state to help parents implement this right, the right to education, and most intriguingly of all, the right to rest and leisure. Getting them up is often more difficult, is it not? To engage in play and recreational activities appropriate to the age of the child, and to participate freely in cultural life and the arts. Well, one might have thought that a rich country like the United Kingdom would be at the forefront of implementing these social and economic rights. We have, of course, had universal state education for more than 150 years, and school is now compulsory up to the age of 16. But socio-economic rights are not contained in the European Convention, and the UN Committee has expressed particular concern about the long waiting lists for children seeking mental health services, and also about the large number of children living in poverty, food insecurity and homelessness. This is their report in 2023. And recent developments in social security law have undoubtedly contributed to this. In 2012, the government imposed the first benefit cap, a limit on the total amount of benefit which a household can claim. This meant that certain households, in particular those with several children in high-rent areas, would not receive the level of support which the government itself deemed necessary to cater for their basic needs. It also discriminated against women, because lone parent families, the vast majority of whom are headed by women, were particularly badly affected. Access to benefits is a property right protected by Article 1 of the First Protocol to the European Convention. And Article 14 says that there must be no unjustified discrimination on grounds such as sex in the enjoyment of those rights. So in the first of the Benefact cases, JS, the cap was challenged as incompatible with the Convention rights. And the government accepted that there was indirect discrimination, but argued that it was justified. Now, part of the argument against this relied upon Article 3.1 of the UN Convention. The government couldn't have made the best interests of the children their primary consideration, as they had promised to do. And that argument came very close to winning the day, but was ultimately rejected by the Supreme Court, which held that the discrimination was justified to save money, to incentivise work, and to promote fairness between working and non-working households. And a later challenge to an even more severe benefit cap, which impacted particularly harshly on families with very young children, also failed. The court held that the government's justification for the admittedly discriminatory effect that in the long term, children in families with working parents fared better than children whose parents were not in work, was not manifestly without reasonable foundation. This was then the test applied to the justification of government measures in the field of socio-economic policy. Lord Kerr and I dissented in both these cases. We thought that the government's reason for depriving children of enough to live on was not good enough in the light of their promise to make the best interests of children their primary consideration. And the more recent case of SC concerned the two-child rule, that child tax credit is not available for a third child. And the Supreme Court basically held that these rules shouldn't be challenged at all. The courts are not equipped to evaluate such policy decisions, which inevitably involve discrimination against women and children. Lord Sumption recently told the House of Lords Constitution Committee that this was a good thing. Courts reining back attempts to challenge decisions which ought to be made by politicians. I didn't argue with him at the time because that would have been unseemly. No. And I agree entirely that there are certain decisions which politicians are much better equipped to make than are the courts. But it is an important function of human rights law to protect minorities from discrimination by the majority being represented by their elected representatives. So I do wonder how far the hold-off can go. What if, for example, the government decided to deprive women of their retirement pensions or black people of universal credit? I cannot think that the courts would think that they were unable to challenge that. So it does look as if, despite the acknowledged obligation to make the welfare of children their primary consideration, discrimination against children is not taken as seriously as discrimination against other groups. And I'm told that these benefit rules are the principal reason why families have to resort to food banks. Now, England has so far adamantly refused to incorporate the UN Convention into its law. The most that has been done is to impose upon certain public authorities the duty to have regard to the need to safeguard and protect the welfare of children when making their decisions, a rather weak way of reflecting Article 3.1. Wales has imposed a duty on public authorities to have due regard to the rights of children under the Convention when making any policy decision affecting them, and to publish their assessment of the impact upon children's rights. And this obviously has an effect on policy decisions. Scotland has recently gone even further and incorporated the United Nations Convention requirements into Scots law in a way which is similar to how the Human Rights Act incorporates the European Convention into UK law. And Sir Andrew was just telling me that on a recent visit to Scotland, it's been having an effect and having a beneficial effect. Needless to say, the UN Committee has urged the UK to strengthen its efforts to fully incorporate the Convention into national legislation in England, Wales, Northern Ireland, and the British Overseas Territories and so on. But the argument against doing so has always been that the rights in the Convention are too vague and aspirational to be translated into enforceable legal duties. So it would be really, really interesting to see how the Scottish experiment turns out. But despite these shortcomings in the UK's implementation of the Convention, we do still have much to celebrate. Recognising that children are people with their own identity and status from the moment they are born, recognising that their best interests should be a primary consideration in all decisions affecting them, recognising their right to be heard and to form their own opinions, recognising that children develop over time, recognising their need to be protected from all kinds of harm, and recognising their need for services appropriate to them as children. All of this is a huge step forward, and we shouldn't let our disappointments with the way in which it may work out in practice blind us to this. I hope and believe that Katherine would have shared all of these views which are offered in her honour and in her memory. Thank you.